Hi, welcome back. In this session, we are going to discuss about some of the selected topics from jurisprudence. Law. Law is defined as the body of principles recognized and applied by the state for the administration of justice. According to Austin, law is defined as the general command of a sovereign. According to Salmond, law is the body of principles recognized and applied by the state in the administration of justice. By Duguid, law as an obligatory cause of human conduct designed to satisfy the social needs of the community. The ultimate aim of law is administration of justice. Administration of justice can be either 1. Administration of civil justice through civil courts. Here, the law enforces rights of the parties and provide compensation for the sufferers. Second, administration of criminal justice through criminal courts. Law punishes the offender or wrongdoer. So, with respect to schools of jurisprudence, we have analytical school of jurisprudence. It analyzes the existing law. It answers the question what the law is. Then we have historical school of jurisprudence. It traces the evolution of law. It answers the question what the law was. Then there is philosophical or ethical school of jurisprudence. It analyzes the relationship between law and justice. Then there is sociological school of jurisprudence. It considers the function of law. It considers law as an instrument of social control. Wherever there is a conflict between private interest and social interest must prevail. So, the elements of law is right, then person, ownership, possession, obligation, liability, title, property, and law of procedure. So these are the elements of law. Now, what is a right? Right is an interest protected by law. An interest recognized by natural law is called natural right. An interest recognized by moral law is called moral right, whereas an interest recognized by the law of the state is called legal right. So what we study here and what is enforceable is the legal right. There are instances where a moral right or a natural right becomes a legal right. Now, categories of rights. There is perfect rights and imperfect rights. The rights which can be enforced through court of law is called perfect right. The right which cannot be enforced through court of law is called imperfect right. Then there is right in personam and rights in rem. So right available against a particular person is called right in personam. Right available against the whole world is called right in rem. Then we have right in re propria and right in re alienea. That is right in re propria and right in re alienum. So, right of one person over his own property is called right in re propria. Right of a person over another person's property is called right in re alienum. So, we have easementary right, that will be an example of right in re alienum. Now, there is positive rights as well as negative rights. Positive rights arise from a positive duty. Positive rights are those which correspond to positive duty. Negative rights arises from a negative duty. Negative rights correspond to a negative duty. That is, when you say that I have a right to do this, that is a positive right. Then, where you have a right, it is another person's duty not to violate your right. So, the other person has a negative duty, that is not to violate your right. So that is a negative right. Now, legal right and equity rights. The distinction is only in England, that is, legal rights are those recognized by the common law courts. That is, the right protected by the court of law is termed as legal rights. Equitable rights are those recognized by equity court in England. So in England there is common law court as well as equity court. So the rights recognized by the common law court is known as the legal right, and by the equity court is known as equity rights. Rights protected by the courts of equity are called equity rights. And then we have personal right and proprietary right. So personal rights are those which constitute person's basic right. Personal rights have no economic value. Now proprietary rights are those which constitute a man's property or wealth. Proprietary rights have economic value. Then there is principal rights and accessory rights. So the main right is called the principal right. The rights associated with the principal right is called the accessory right. Then there is primary right and sanctioning right. So primary rights have some source other than wrong. A sanctioning right originates from the violation of another's right. Then there is public rights and private rights. The rights vested in a state are called public rights. Rights belonging to the individual are called private rights. And then there is vested right and contingent right. So the rights vested to a person by means of occurrence are called vested right. The right obtained by a person by means of fulfillment of a certain condition is called contingent right. So with respect to right and its categories, we discussed perfect right and imperfect rights, rights in personam and rights in rem, right in re propria and right in re aliena, positive rights and negative rights, legal rights and equity rights, personal right and proprietary rights, principal rights and accessory rights, primary right and sanctioning rights, public right and private right, then vested right and contingent right. The next element is the person. A thing which has rights and duties is called a person. The term person is derived from the Latin word persona, which means that mask worn by an actor. Person may be of different types. They are natural person, artificial person or legal person, dead person and unborn person. And the next element is the ownership. It is the relationship between person and an object. The basic feature of ownership are: 1. The owner has possession right. 2. The owner has the right to use and enjoyment. 3. The owner has the right to consume, destroy or alienate what he has owned. 4. The owner has the right to perpetuity. 5. The ownership has a residuary character. Now, there are categories of ownership, that is corporeal ownership, incorporeal ownership, sole ownership, duplicate ownership, vest ownership, contingent ownership, legal ownership, equitable ownership. The next element of law is possession. It is one of the most important rights in law. It is the prima facie evidence of ownership. Possession may be either in fact or in law. Possession in fact is also known as de facto possession. Possession in law is known as de jure possession. These are the essential elements of possession. The possession can be of two types, that is corporeal possession as well as incorporeal possession. Now towards obligation, that is the next element of law. It implies a duty. Obligation means a duty in personam or right in personam. According to Salmond, obligation as proprietary right in persona or a duty which is correspond to such a right. And when there is duty, there is liability. So with obligation, there is also liability. It is a bond or tie which comes in existence when there is a breach of an obligation. Liability is a responsibility of a person which came into existence when there is a wrongful act of the person. Liability may be civil or criminal. The next element is title. It is a source of a right. Person obtains right from certain title in his favor. According to Salmond, title is de facto antecedent of which the right is the de jure consequent. So, according to Salmond, title is the de facto antecedent of which the right is the de jure consequent. So, the types of title, there is original title and there is derivative title. Then there is property. The term property means any asset in the name of a person. The legal sense, property means proprietary right in rem. Now there are different types of properties, that is corporeal property, incorporeal property, movable property, immovable property. Then there is law of procedure. So law is the body of rules recognized and applied by the courts of justice. Administration of justice means not only to define the law but also to provide the ways and means of enforcing them. The law of the land can be divided into two. They are substantive law and procedural law. Now, legal theories. It is the inquiry into the evolution of law. Different legal theory provides proper solution to the origin of law. The major theories with regard to the law are natural law theory. Here, under natural law theory, it is said that law is evolved from the nature. Law is formed and not made. That is discovered and not invented. So, that is the natural law theory. Then there is positivist theory or imperative theory. This school says that, or this theory says, law is not found but made. John Austin was the chief exponent of this theory, that is the positivist theory or the imperative theory. Then there is the pure law theory or Kelson's pure law theory. Here, Kelson is the exponent of this theory. According to him, law is a pyramid of norms. In every society, there is a basic or ground norm. Then there is the social engineering theory. Roscoe Pound is the exponent of the sociological jurisprudence. He says law is not for individuals but for the societies. Whenever there is a conflict between individual interest and social interest must prevail. Now, towards the sources of law, the primary sources of law is the constitution, legislation, customs, precedents, that is the precedents which is judicial decisions. Then we have statutes, rules, orders and notifications, bylaws, etc. So these are the primary sources of law. These are the major sources of law. In addition to these, conventions are also regarded as sources of law with regard to the parties to the agreement. So there is international conventions, treaties, etc. For example, international conventions are binding upon the state policies. The UN Convention on the Law of Seas, UN clause, is one such example. Going towards the Constitution, it is the basic law of our nation. It is the basic law and all other laws are derived from the Constitution. Then we have legislation. It is the law made by the law-making body, that is the legislature. Legislation may be supreme legislation and delegated legislation. The law made by the legislature is called supreme legislation. The law made by the executive body is called delegated legislation. And then custom as a source of law. The authority of custom is based on the maxim via trita, via tuta. That is, frequent path is a reliable path. Via trita, via tuta. But all customs cannot become law. Only a valid custom becomes the law. So what makes a custom a valid custom? So towards the essentials of valid custom, one, it should have antiquity, that is immemorial antiquity. Two, reasonable. Only reasonable customs can be made a valid custom. Then peaceful observance, continuity, certainty, observance as a right, and conformity with the statutes and other customs. So these are essential to make a custom a valid custom. Then there is general custom and local custom. A custom which is followed throughout a state is called general custom. If it is followed only by people in a particular locality, it is called local custom. Then we have precedence as a source of law. So the doctrine of precedence or the stare decisis principle means the decision of the higher court shall not be disturbed. Let it stand as it is. So it is also known as the doctrine of stare decisis. The doctrine was evolved by the England judges, but today the doctrine is having only limited application. The judges can change their previous decision. The House of Lords, through their practices statement, declare that judges can deviate from their decisions if there are compelling circumstances. How to find ratio decidendi? So every decision or every judgment must have a ratio decidendi. That is a reasonable reason for decision. There should be a reasonable reasons for decision. That is a ratio decidendi. So discussing the importance of the doctrine of stare decisis, why we use it is depending on the ratio decidendi. So how to find out the ratio decidendi? We have Dr. Van Bogh test. The test of inversion or reversal. Take a proposition and insert the word not. That if it gets reverse meaning, that proposition is taken as a ratio decidendi. Then we have Dr. Goodhart test or the material fact test. So for regarding the finding of ratio decidendi, we have the Van Bogh test and Goodhart test or the material fact test. With respect to Dr. Goodhart test or the material fact test, ratio decidendi must be ascertained in the light of the facts which are considered as material by the judge while deciding the case. Now, there are types of precedents, that is the original precedent, delegatory precedent, authoritative precedent, and persuasive or influence precedent. Now, the next source of law is the statutes. The law enacted by the legislature is called statute. A statute consists of the following components, that is the long title, preamble, short title, commencement and extent clause, then definitions, then the operating provisions, then procedural provisions, exceptions, provisions regarding delegated legislation, and finally the repeal and amendment clause. Then there is rules, orders and notifications. Certain lawmaking powers are delegated to executives due to many reasons. The law made by the executives for informing or implementing certain things. Any rule made by the executive is called rules. Any order passed by the executive is called orders, and any notification made by the executive is called notification. And then we also have bylaws. Any regulation, ordinance, rules, laws, etc. adopted by an association is called bylaws. Then, where these are the primary sources of a law, there are secondary sources of law. That would be textbooks, digest, encyclopedia, commentaries, law journals, law commission reports, other reference materials, constituent assembly debates, legislative assembly debates, etc. So this is about some of the selected topics with respect to jurisprudence. I hope this is helpful. If you like it, please Click the like button. If you have not subscribed, please subscribe to the channel. If there is any feedback, please drop your comments in the comment box. Thank you. Thank you for your support. Have a nice day.